welcome. Welcome. If there are in the audience any of our own clients, welcome to you all as well. We have a packed program for the next, let's say, 75 minutes. So we'll try to move as fast as we can. Don't hesitate to ask your questions in the chat if you have any. We will try to incorporate them in a short Q&A session after each of the presentations. The idea is to make as much time as possible for interaction with you guys rather than spend our time on extensive slide presentations. Nobody likes to hear lawyers talk about the law, so we'll try to make time to listen to your questions. All right, you can move to the next slide. Short intro on today. We live in a rapidly changing society. I noticed from our own practice that things like artificial intelligence, Internet of Things, are developing rapidly. We do a lot of work in marketing. I see that marketing automation and all kinds of smart marketing tools are developing at speeds that we could never imagine before. Along with that comes an ever-growing cybersecurity threat. The number of cyber attacks has risen exponentially over the past few months due to Corona, COVID as well. We'll talk about COVID later on today. All of that, I have only one word for that, and that is a digital revolution. We had an industrial revolution 200 years ago, 150 years ago. We're in the middle of a digital revolution today. And in the middle of that revolution, I hear a lot of my clients and contacts say, well, data protection, that's a bit overrated. I have nothing to fear for. I have nothing to hide. My data isn't secret. There's nothing that the world can't know about me. I don't believe that. I think that's a mistake. And I think that a great writer already said that a long time ago. We all have secrets. We all have private lives that we don't need everybody to know about. Everybody has secrets. Everybody has things that they don't want to share with others. And most of you listening today work for companies. Maybe you're lawyers as well. Maybe you're in a more commercial or technical function, and you represent your company. And your company wants to process data, use data, gather data as well as they can. But something that we can't forget, all of us, is that in the end, when we go home at night, all of us are just persons. We all are data subjects, and our data is being processed as well. So we should all care about ethical, correct, respectful data processing. And a few of the things that we want to discuss today is how to do that in an international context. Data transfers between countries. We'll try to discuss that on a global scale. We'll try not to discuss purely because most of the panel members today are from the EU. We'll try not to spend too much time on GDPR, but have a look at data processing around the world. All right, but the first subject, and that's on the next slide, and I'll be short on that because we don't want to do GDPR extensively. The first small topic today is a small celebration of 2 years of GDPR. Everybody that is listening today and that has a company in the EU or a branch office in the EU or does business with the EU or the EU and the neighboring countries will know that the General Data Protection Regulation in the EU has celebrated its second year of being into force almost 3 weeks ago now. So I've gathered a few statistics on two slides. First slide, one of the things that we've seen in a number of countries over the past 2 years is that fines controls by Data Protection Authority started slowly. Some of the countries were very fast to start enforcing GDPR and imposing fines. A lot of other countries, amongst which my own country, took quite some time before they started imposing the first fines. After 2 years, what we see throughout the EU is that 260 fines have been imposed. Those are financial fines. There are a lot of other decisions that have been pronounced. Sometimes just warnings, sometimes orders to stop processing or interdictions or orders to stop certain types of processing. The financial fines up until now, 260 in 2 years throughout the EU, for a total amount of 460 million euros. 460 million euros, over $500 million for friends across the ocean. That is a lot of money. At the same time, it's not that much money if you take into account that this is spread over 27 countries, and that 2 or 3 of the really big fines make up a lot of that money. Google alone in France ran into a $50 million fine. Um, so if you take away the big ones, then most of the fines will be anywhere between 1,000 and 100,000 euros. That's the second thing that we've learned, I think, over the past 2 years. A third thing that we've seen is that not all countries are equally active in imposing fines. The highest number of fines that we've seen over the past 2 years are in Spain, Romania, and Hungary. Some of the countries have a few dozen of fines so far, including Spain. If I look at my own country, Belgium, there are 5 or 6 GDPR fines in 2 years so far. So two, different weights, different standards for different countries, unfortunately, because the entire idea of GDPR was to unify. The highest total amount of fines, that as well is very different. We see that the highest total amount is in the UK, Italy, and France, which are also, together with Germany, the biggest countries. So it would be logical that the highest total amount would be found in any of those countries. But there again, we see very large differences between the fines that are being imposed. Again, in my own country, in Belgium, very often up until now, it's a few thousands of euros. If I compare that to the UK or to Italy or to France, the numbers per individual fine are way, way higher. So again, we see unequal treatment between member states, despite the fact that GDPR is supposed to be a unifier as far as data protection goes. And then the last thing that I've learned from an overview of 2 years of GDPR is that the reason why you will get a fine in the EU is, before all, a lack of data security, data breaches, cybersecurity threats that aren't handled correctly. That will be your number one reason to run into a fine. If ever your company is the victim of a cyber attack, not only it will cost you a lot of money to solve the problem, but on top of that, you will have to contact the authorities, then do a data breach notification. And if it turns out that you didn't take adequate measures to prevent the data breach, you will get a fine on top of the problems that you already have. Second most important reason to run into fines is lack of proper legal basis for processing. Those are the legal grounds. Did I get an opt-in? Do I have legitimate interest? Can I process because the law forces me to? In a lot of cases, that is there is an issue with that. And the third main reason why you will run into fines is lack of respect for basic principles, basic data subject protection principles, like transparency, being able to reply to data access requests, not being able to delete data when data subjects ask you to delete data. So that's what 2 years of GDPR shows us. That, together with the fact that throughout the EU, I think over 50% of all companies and organizations that are subject to GDPR are not yet compliant, which is a lot. I think we can skip to the next slide. So that's a situation today. And then for those of you listening that are non-EU companies, I tried to list 5 things that you really should know if you're going to process data belonging to persons that live inside the EU. The first is you should be aware of the fact that GDPR has an extraterritorial scope. That means that it will apply to a lot of companies that do not have a seat in the EU, just by the simple fact that they are processing data from people living inside the EU. We will come back to that in one of the next presentations later on this afternoon. The second most important thing to, or a second important thing to know is that data exporting from the EU to the outside world is not easy. There are strict limitations. Laura will give us an overview later from our Italian member firm. Will give us an overview on the rules you should respect when you're exporting data outside the EU. We've had a number of issues with clients that use call centers, for instance, telephone call centers outside the EU. They're very often exporting telephone lists, contact lists outside the EU. There are very strict limitations. The third, and that is the core of GDPR. That's what GDPR is all about. What you have to do also, if you're not an EU company, is being able to demonstrate that you have taken appropriate measures in order to ensure an appropriate level of protection, which is an absurd concept in my eyes, because nobody will tell you what appropriate is. You have to find out what appropriate is for yourself. And today you will have to decide to implement certain measures to reach an appropriate level of protection. And post factum, afterwards, if there ever is an issue, we will come back and look at what you decided today, and we will judge retroactively if what you did today was sufficient to ensure an appropriate level of protection. Very difficult exercise to make. What this requires you to do is make a gap analysis or a risk assessment on your entire organization. Watch out if you're processing data belonging to EU citizens, because you will most likely have to designate a representative in the EU. That can be a lawyer, consultant, anyone that will represent your company within the EU. And even if you're not an EU company, you may have to decide to appoint a data protection officer, which is, in simple words, an internal compliance officer that has to make sure that GDPR is respected within the organization, and that will be a contact person for the outside world. That is, in a few minutes, more than I wanted to take, but in a few minutes, what GDPR says, or what we have learned from 2 years of GDPR. Now, are there any questions from the audience on this subject? Not so far, none so far as I can see. Is there anything that any of the panel members wants to add to this short overview?
Yeah, I'll just jump in here, Bart, about the perspective from the UK on the level of fines. They have the Information Commissioner's Office in the UK has given its notice of intention to fine 2 companies, very large amounts, but those fines haven't actually been imposed yet. So the companies involved, Marriott Hotels and British Airways, are making representations to the ICO at the moment, and the level of fines haven't actually been decided yet. So that's just a point to note.
Okay. Any other experience from any of the other EU member states on the number of fines or the level of fines? I learned yesterday, and with that we can perhaps move to the next topic. I learned yesterday that the reason why Spain is in the top 3 of countries that has the highest number of fines so far is that the Spanish authorities have to finance themselves, auto-finance, by the money they can collect through fines, which is a very effective way to make sure that your government officials do their work and are efficient, because they will pay their own wage based on the fines that they can impose. Interesting one. Maybe the other member states should look into that to be more efficient. All right. If there are no questions on GDPR, then perhaps we will move to a second topic today. That will be on the next slide. Gwendal Barbeau of IPSIDE in France will give you a short presentation on how to be data protection compliant across different jurisdictions. If you're going to process data in different countries, what should you know and what should you be aware of? Gwendal?
Thank you very much, Bart. So next slide, please. So we start with an overview of national legislation across the globe. Next slide, please. So to sum up, 66 of states have adopted data protection legislation, whereas 10% have a draft legislation. Just in 2020, Data protection law are coming into force in India, Thailand, Brazil, South Korea. So we will soon arrive to the point that a great majority of countries will be bound by data protection. But the problem is that there is no global framework, and there are big differences between the various legislation. One big difference between the various systems is whether the data processing activities require or not registration. So, for example, no registration requirement in Australia, China, or EU versus registration requirements like in Argentina, Tibetan, Indonesia, and even inside the EU, and despite the GDPR, country keeps some specificities. And even inside the same country, such as federal countries of Australia, USA, you can have some specificities. So this creates uncertainty for a company. So the creation keys, what are the steps to be taken to achieve worldwide compliance. Next slide, please. The first step is to identify which rules apply to your target country. So obviously, there are a lot of information available, and notably on the website of the various national data protection offices. But the difficulty is how to use it. So to be very honest, the first step and the first advice would be, before all, to consult your lawyer and get local help. You get help for step one, how to identify and how to use the information. And you're gonna get help of your lawyer as well for step two. Next slide, please. Be aware, as you said, Bart, of the extraterritorial scope of some data protection legislation. So some legislation, as you said, has extraterritorial effect, which means that even if your company is located in one country, a foreign data protection law could apply. That's the case for EU rules, that's the case for Japanese or Brazilian rules. So you will very quickly face a conflict of law. You have to apply your local law. You have to have applied the law of your target country, and then you have to face extraterritorial rules. So that is why, as an expert in data protection, we need to work together with foreign colleagues to enable us to draw up a proper compliance policy. And that is true that, practically speaking, belonging to an international network of lawyers is quite efficient. And this will enable to go through step three. Next slide, please. So step three gives example of the data export checklist. These are examples of issues that are raised to try to set up compliance policy. And these are like an example, but there are obviously more questions. And as again, potentially you can face a conflict of law. We will, on the worldwide prospect, we will try to reply to all the questions together, again, with all the potential foreign colleagues that would be involved, depending of the law that will be implied by the cross-border data flow, by the application of potential extraterritorial scope, in order to try to answer on the case-by-case basis of all the questions that are raised, and in order to try as best as possible to draw up a proper compliance policy. Yeah, so Bart, I guess that you have some questions in this respect.
Thanks. Thank you very much, Gwendol. So far from the participants, only one question from Julia that doesn't directly relate to your presentation, but I do want to answer it. Julia is asking us, since we're all privacy professionals here, why was Zoom chosen as a webinar platform instead of a more ethical European solution? Just justified question. I think there's been a lot of discussion about Zoom over the past few months. Only I think that Zoom has come a long way over the past few months to comply a lot more to GDPR in the EU. So I think that most of the issues have been resolved for the time being, and it's quite simply one of the most commonly used, most well-known webinar platforms for the time being. So user friendliness and accessibility for everybody is the reason to choose Zoom for the time being, together with the fact that I am quite certain that we will not be discussing a whole lot of confidential information during this session. So the risk of painful data breaches should be limited. All right. Wendell, or the others perhaps, very interesting talk on what you should be aware of before you start processing data across country borders. In general, how would you say your clients are aware of the fact that shifting data from one country to the other might have consequences? Are they aware of the risks? Are they aware of the fact that they may run into problems and fines in other jurisdictions on the other side of the world?
Usually not, really. Usually not. They start to be aware of, and especially after 2 years of implementation of the GDPR, they start to be aware of it. But usually they are not. No.
Mm-hmm. It's a pity because the risks are real, I think.
Are really high? Yes, absolutely. Yeah.
Catherine, one of the things from the US, Catherine Lewis, one of the things I saw was that 66% of all countries have started to implement or have implemented data protection laws. What we say the situation in the US is because we've all heard of CCPA by now, but are there any other states within the US that are implementing new legislation?
Well, new, not so much. It's a bit of a mixed bag. I think there was a law that was introduced in Washington state that was recently killed again on the second time through. Texas already has some state level data privacy and security laws in place, but they had also been proposing 2 new bills pre-COVID that were very similar to the CCPA with some slight modifications, including things like, and they weren't going to provide a private right of action, for example. But those 2 bills have stalled with the advent of COVID, so they haven't been canceled, but they are pending essentially now, whereas they were expected to go for a vote. The state in the U.S. is that many states do have their own privacy laws that are related to privacy. Some of them, for example, in Connecticut, there's old legislation on the books about protecting social security numbers. So the robustness is what varies across the states, and it's a bit of a patchwork. And then at the federal level, there is, as many people on this call probably already know, there is no federal omnibus sort of overreaching data privacy and security law, but there are federal laws that apply to industry specific practices, including the healthcare industry or securities industry, children in specific. So we do have those types of federal laws that apply across the board, and the Federal Trade Commission is sort of I would say that they're basically the unofficial regulatory body at the federal level for most things really that touch on data privacy and security, but not through a direct means, as in the case of GDPR, or in other countries like Brazil or Turkey that have adopted very similar legal frameworks to GDPR.
So does that mean if I'm, let's say, for instance, an Asian or a European company that wants to offer services online in the US, does that mean that that I have a lot of homework to make before I can start? Do I have to compare?
I would say, usually what I ask my clients is, where do you think you're going to be primarily practicing? Where's your business going to be, focused most in a geographic sense? So if it's in New York, if you're coming over from overseas, then you're going to just be based in New York, and you'll operate a website which may capture residents from other states within the U.S. You may not meet, for example, the threshold of CCPA for doing business within the state of California. But there's more privacy legislation in California than just CCPA. There's also the California Shine the Light Act, which would apply basically to anyone who operates a website. So we would, have discussions with the client about that level of compliance, but it doesn't even, it's nothing compared to CCPA. So it's a bit of a discussion, I think, like all privacy, data privacy and security compliance, consult is. But I try to be really fact intensive with my clients, so that we're structuring and working with them to develop a solution that mitigates their risk. It's really difficult to eliminate all risk in this area.
All right. Difficult situation, if I understand correctly. We have the luck of having amongst our panel members Lucia from Horizons in China. Lucia, how do you look at GDPR on the one hand and the patchwork of American legislation on the other hand from a Chinese perspective? Because it may come to a bit of a surprise to some people to know that China itself has pretty strong data protection rules as well, don't they?
Yeah, yes, I think that in the past, I listened that someone usually said that the China rules in this regard was in the middle between Europe and US. In reality, China is a totally different country in a lot of issues and also in this regard. Because in China, yes, we have a law that is the cybersecurity law that is effective since 2017, and then we have a lot of specification that shall mean some clarification of such law. But the basis of such law, comparing with EU or US, is totally different. Because in such legislation, you have to take care about the individual and about the right of the individual to have the protection of the personal data, the proper collection and treatment. From the China perspective, the basis of the cybersecurity law is to protect the collective data. So the data of the population of China, the data of the territory. This is a totally different basis, and the law is implemented according to this. I would like to take you one example. If, for example, a third party would like to go to the administration of commerce in China and to obtain the financial statement of a Chinese company, it is not possible because such data is not a public data, but not to protect such company, because the interest that is under the financial statement of a Chinese company is a collective interest. If you disclose the financial statement of a Chinese company, you are disclosing the economic issue of the Chinese perspective in general. So I think it's interesting to understand this, because also the way that you have to analyze the cybersecurity law and in general the Chinese law is different comparing with the European law and the US law.
Right. I understand that European or American companies that want to start a business in China have a lot of work just in understanding the cultural differences before even starting to implement any legal solutions, if I understand correctly.
Yes, because they are really connected. It's necessary to understand, such issue locally, because the cybersecurity law has to apply to all the China-based companies, including the foreign invested companies. Also because since this year, 2020, in China, we should speak only about company. There is no more the difference between the foreign invested companies and the Chinese and the companies constituted by Chinese. So they are equal. So if you are a foreign invested company in China, you have to comply exactly with the same rules that could be applicable to the Chinese companies. So as you said, it's very important to understand the local rules and also the culture in China. And I would recall what Wendell said. In this regard, what we are doing with our group is absolutely this. We would like to work locally as local law firm because we are expert in this jurisdiction, but we work in international level because we work together to comply with all the relevant legislation.
That's a very nice summary, Lucia. Thank you. I've only also understood from the past 20 minutes that as soon as you move across borders, things get very complicated. Rules will differ from country to country. Even within some countries like the US, the rules may change from state to state, and you really need somebody in the field that knows the local situation to help you move forward. All right. I propose we listen to Laura Borzoni of Loyalty in Italy and David Schenker of Advotech in Switzerland. They will discuss cross-border data flows with us. I'm curious to hear what they have to tell. Guys?
Thank you, Bart, and good evening to everyone. I would like to start with a practical case as a point of analysis of cross-border data transfer. Thank you for the slide. The parent company of an Italian company wants to transfer the data of employees, customers, and suppliers to a server placed inside the company's headquarters in Hong Kong. So, what we have to do in order to transfer the data in compliance with the GDPR. Next slide, please. The principle to keep in mind is that any transfer of personal data outside the European Union is prohibited unless the country in question guarantees an adequate level of protection. How do I know if the country where I have to transfer the data has an adequate level of protection? The answer is I have to check if the country to which I want to transfer the data is included on the list of compliant countries of the European Commission, published on the official journal of the European Union and on its website. Now, what happens if the country is not in that list? For example, in our case, Hong Kong is not there, so what can we do? GDPR can help us. In fact, it provides a list of cases of derogation from the prohibition of transfer, which includes, for example, the explicit consent of the data subject. But our case doesn't fall within the list of exceptions. In fact, even if we obtain the consent of all employees, how to deal with customers and suppliers, given that when I send such request, I almost never receive a reply. Unfortunately, I cannot transfer the data in this way. So what to do? We can take into consideration the contractual measure provided by the GDPR. Next slide, please. The first measure to take into consideration are the standard clauses, which are standard contract clauses prepared by the European Union, the European Commission, that can be included into the data transfer agreement. They have the purpose of contractually binding the data receiver to the adoption of adequate safeguards on the data transmitted. They can be copied word by word. So, to summarize, I can transfer data outside the European Union if there is a contract, such as a supply agreement, between the parties. But what happens if there is no contract between the parties? The answer is, if there is any written contract, but we are part of the same group, we can use a measure called binding corporate rules, which are contractual clauses that provide common principles and that are contained in a specific agreement between the group companies that contractually undertake to respect them. So we have found a way to transfer data between companies of the same group. Now, it seems that we have solved the problem, but unfortunately, it is not that easy. In fact, if on one end, the Commission gives us the chance to transfer data outside the European Union, on the other end, it intervenes with a lot of bureaucratic obligations. The binding corporate rules, in order to be approved by the competent supervisory authority, must comply with specific requirements, such as, for example, the preparation of training course for the person in charge of the processing. Then, all the documentation prepared must be sent to the competent authority for approval. We suggest to pay attention because the involvement of the authority could expose your company to further control. And that's a bit like having the enemy at home. It's not over. In fact, the last step is to submit everything also to the European Supervisory Authority. And even in this case, specific procedures are required. It is clear that the choice of the correct measure is not trivial, and that every situation must be assessed on a case-by-case basis with the necessary assistance of a professional. Thank you for your attention.
Thank you, Laura. Yeah, David, maybe you should continue with your slides before we jump into questions indeed.
Okay, I'll do that. I would like to supplement Laura's presentation by providing you with a Swiss perspective of cross-border transfers. So as you probably all know, Switzerland is not a member of the European Union or of the EEA. That means that Switzerland has its own data protection law that apply to cross-border transfers. The good news is that the Swiss rules for cross-border transfers are quite similar to those of the EU. That means that cross-border transfers are generally only possible if the recipient country has an adequate level of data protection. Whether this is the case can be assessed by consulting a country list that is published by the Federal Data Protection and Information Commissioner on his website. According to that list, all member states of the European Union and of the EEA have an adequate level of data protection, as have all the countries that have an EU adequacy decision, except for Japan. The US is a special case. The US itself is not listed as having an adequate level of data protection. However, if the recipient of a personal data has self-certified under the Swiss-US Privacy Shield framework, then there is an adequate level in relation to that recipient. The UK is another special case. According to the list, it has an adequate level of data protection, but because of the uncertainties in relation to Brexit, the Commission has clarified in January of this year that for the moment this will remain unchanged. However, the Commissioner will continue to monitor the situation, and it is probably likely that he will follow the EU's lead should the EU decide that the UK no longer has an adequate level of protection. So at the moment, transfers of personal data from Switzerland to countries which are listed as adequate is possible. Always provided, of course, that all other data processing requirements under Swiss law are met. So, for example, limitations with regards to certain restrictions in relation to sensitive personal data, such as health data or criminal records. There may also be sector-specific restrictions. Because of the relative uncertainty in relation to Brexit, it is also advisable in relation to transfer to UK to have contractual obligations in place that the parties will conclude appropriate data protection agreements, such as the EU standard contractual clauses, if the UK should no longer be considered to have an adequate level of data protection. Now, in relation to all of those countries that do not have an adequate level of data protection, the transfer of personal data from Switzerland is still possible if the adequate level of data protection is ensured by other safeguards. The most practical among these safeguards is the conclusion of standard contractual clauses provided by the European Commission. The Federal Data Protection and Information Commission has recognized that these standard clauses can also be used for transfers from Switzerland. However, because the European Commission did not draft these standard clauses with Switzerland in mind, some clarifications are necessary for them to properly apply to transfers from Switzerland. So, for instance, the term member state should be extended to also include Switzerland. Now, at the moment, there are currently two sets of standard contractual clauses. One is for controller-to-controller transfers, and one is for controller-to-processor transfers. And this brings us to quite tricky questions, namely, which of the parties is the controller and which is the processor? Or are they both controllers or possibly even joint controllers? Now, to understand, the controller is usually the party that determines what the purpose, means, and content of the data processing is. The processor, on the other hand, is usually the party that processes personal data on behalf of the controller. The distinction is important as it is used to allocate responsibility for the processing of personal data and the obligations related thereto. This is, for instance, relevant with regards to the implementation of appropriate technical and organizational measures required to ensure security of personal data. The applicable law may also require the conclusion of specific contracts. This is, for instance, the case under GDPR, which requires such contracts for control-to-process relationships. To complicate matters, a party may be both controller and processor at the same time, but in relation to different processing activities. So unfortunately, the distinction is not always an easy one to make, and to assess the situation in a given case, it is therefore often advisable to seek expert advice. Thank you.
All right, thank you, David. One of the things that that struck me in your presentation was that, if I understand correctly, if no Brexit deal is found between the UK and the other EU member states in the upcoming months, the cynical consequence might be that exchanging data between the EU and the UK might become more complicated than exchanging data between Switzerland and the UK, Switzerland not being an EU member state, because for the time being there is no adequacy decision between the UK and the EU, and it's already been announced that it will take some time for the UK to obtain an adequacy decision if they request one. So that might make of Switzerland a preferred partner for the UK for data exports in the future. Or
maybe, well, at least for the moment. Just as I said, I mean, if the EU will decides that the UK no longer has an adequate level of data protection, it is likely that the Switzerland will follow suit and also basically say that the UK no longer has any adequate level. But until that time, yeah, we still have basically adequacy between the two countries.
Right. Catherine from the US, the entire discussion on Privacy Shield, EU-US Privacy Shield and Switzerland-US Privacy Shield, as long as it will stay in place, because there's a lot of discussion on the legal basis of the Privacy Shield, but that's that apart. How would you say American companies are aware of what Privacy Shield is and what it means and how they should comply? Is that something that they are aware of, or?
I think it varies. My impression is that the more sophisticated the client or the company, the more aware they are. My firm, we work with a variety of different levels of, size companies, small businesses, mid-size, and enterprise. And so I do find that typically some of the startups that I work with are more sophisticated because they're spin-offs, they're startups that are being founded by folks that are coming from larger companies and have a greater awareness of the power of data and the fact that they need to check all the boxes in order to really leverage that asset and on a moving forward basis. So, but I work with plenty of clients who are not aware of the Privacy Shield. And I also work with plenty of attorneys who are not necessarily as aware. And my own personal reflection on that is that when GDPR came out, I think there was a lot of uncertainty. There were a lot of programs that came out related to whether or not the Privacy Shield would remain intact as far as, you know, from my perspective, the US relationship with the EU. And there was a lot of talk about the fact that it had been obliterated and undermined by the GDPR. And so sometimes I feel that, you know, in the conversations that I have for folks that are not as aware, they were aware in that moment, and that's the soundbite that they heard. And, you know, so the ongoing awareness that the Privacy Shield is still intact and a method of doing business isn't really at the forefront of the mind, that hasn't really been carried through in the last 2 years. That doesn't mean to say that no one knows. It's just, that's sort of my own observation. That's where people sort of left off with their attention span.
What always surprises me is that European companies are not really aware of the danger of exporting, the risk of exporting data to the US or to other jurisdictions. And they don't stop to ask themselves the question, will the recipient, the processor usually on the other side of the world, will they treat my data in a secure and safe way? And that brings me to something that I wanted to ask to Laura on her presentation. One of the things I've seen with a number of my clients is that they ask their counterpart on the other side of the world to sign a data processing, data export agreement containing the standard contract clauses by the EU. And on the other side of the world, companies will just say, okay, just give me the document, I'll sign, whatever, let's just do business. Which means that in a lot of cases, those standard contract clauses are, in my honest opinion, nothing more than a piece of paper that doesn't reflect reality. Is there any way, in your experience or any of the other panelists, to ensure that a company, a partner on the other side of the world can actually back what they're promising in those standard contract clauses? Because in most cases, people don't even read what's in them, I think.
I can jump in here, Bart, if you like.
Laura is on mute. I think she
Laura is on mute. Meantime, Karis, your opinion?
Generally, there's no way to...
Sorry.
Go on, Laura, sorry.
Okay. Yes, what you say, it's correct. It's very important that companies understand that it's not just like a paper. They also have to improve and to understand what they are implemented.
Should you go so far as to hire someone locally to run an audit or a check on that company, or is that too much? Or is there any way to assess what the risk is and what you should do, or should you just go with written declaration that says, okay, we comply, whatever? Karis, you wanted to?
Yeah, I mean, you've mentioned auditing. I think having the right to audit them within your written agreement is important, so that they have to allow you to do that if you choose to, if you become suspicious or worried about anything during the relationship. There's not actually a data protection specific international standard at the moment, so it is difficult to do your due diligence on somebody without physically auditing them, I think.
Yeah.
I agree with that as well. Yeah.
Difficult. Huh?
I would also to jump in for China, because as you know, China is one of the countries that in the people's imagination could create a lot of problems in terms of data protection. But I think that in this regard, I agree with you that the contract should be not a piece of paper. And so, for example, what we usually do is to help the foreign companies to understand the local rules and to understand how the counterparties is implementing such rules. At the same time, so we usually prepare the contracts that could comply, for example, with the Chinese rule, because the Chinese companies has to comply with the rules. but they can also comply with other legislation. So if we can compare the different legislation, we can prepare a customized contract. This is an issue that the Chinese company could accept, but as we said before, it's necessary to work together in this regard to avoid to have really a piece of paper that is not useful for nobody.
Yeah, it's not always easy to find somebody locally that can assist you. Maybe that is let's auto promote. Maybe that's something where a network like Consulegis might be of use to companies.
Yeah.
One of the things that we've used a few times now is vendor assessment forms, questionnaires, where we will ask a specific number of questions to the recipient company, where they will have to say, yes, we did this, no, we didn't do that, yes, we did this. But the same problems remains. It will always be a statement, a written statement that and you can never see if they can back it in reality. So that is one of the risks indeed, and one of the reasons to get help locally, I think. All right. Cross-border data transfers, more headaches, if I understand correctly. Maybe the next speaker can give us a story with, oh no, this is going to be even more headaches. I wanted to say this is going to be something with less headaches, but Caris Thompson from Keebles in the UK, the impact of Brexit on data protection. Please, Caris, entertain us.
Yes, that's okay. Thank you. Hello, everybody. Next slide, please. So just to recap quickly on where we are with Brexit. So the UK left the European Union on the 31st of January this year, and we are currently in the transition period, which is due to end on the 31st of December this year. There is a lot of discussion around whether that transition period will be extended or not. It is possible within the withdrawal agreement for the transition period to be extended once. And I understand that the EU is open to that possibility, but the UK government's current position is still very much that it won't be requesting an extension. So we are still currently in negotiations for the future relationship between the UK and the EU. That period of negotiations will continue over the summer because of the difficulties from the COVID situation. I think the plan is to carry on with some urgency over the summer to try and reach an agreement on the future relationship. And during that time, we also are waiting with bated breath to hear whether the EU will provide the UK with an adequate decision to confirm that the UK, from the EU perspective, has got an adequate level of protection. So during the transition period, from a data protection point of view, the EU GDPR still applies in the UK, and the UK is generally regarded as a state within the EU, for data protection purposes. The UK can also benefit from the one-stop shop, so that it can, if an organisation in the UK has the ICO as its main supervisory authority, it doesn't then have to deal with other supervisory authorities around the EU as well. So that's where we are at the moment. What happens in the future? Next slide, please. So if we leave without a deal at the end of 2020, which is looking increasingly likely, we will have the UK GDPR, which is actually already in place under the Data Protection Act 2018. This is very similar to the EU GDPR. It effectively mirrors it with the same fundamental principles behind it, the obligations and rights that organisations are used to and that data subjects have become familiar with. So a lot of it will stay the same. There are some differences, which is important to get to grips with if you're dealing with processing data within the UK from 2021 going forward. The Data Protection Act applies across the whole of the UK, so England and Wales, Scotland and Northern Ireland. And it also has extraterritorial effect, scope, which we have already mentioned earlier on that a lot of data protection legislation does. So the UK legislation will apply to processing of personal data by controllers and processors with a physical presence in the UK, and also to processing activities in relating to a data subject who is in the UK at the time. They don't necessarily have to be UK resident. As long as they're in the UK at the time, then the legislation will capture them. And the other thing to mention on the UK GDPR is that the level of fines in the UK are going to be consistent with what's possible under the EU GDPR. From the EU perspective, going forwards, the UK will become a third country. So transfers of personal data will be the biggest impact of Brexit without a deal on this specific issue. Next slide, please. So the lawful, to ensure that any transfers of personal data involving the UK remains lawful, the thing for you to establish is where the personal data is collected and where it's going to and where it's coming from, because there are some differences depending on the direction of travel. And I don't think any of us at the moment has mentioned that a data transfer does not necessarily mean it has to be a physical transfer of data. It can be access to it from another country as well. So if you are transferring data from the UK to another country, then if you're compliant now, then there's effectively no change, because the UK has temporarily recognised all of the countries that are regarded as adequate by the EU. So it's maintaining the current position for now. They haven't given any announcement of any intention to change that position. In relation to personal data that is being transferred from the EU into the UK, that is where there's going to be some change if there's no adequacy decision for the UK. So you will need to make sure that there are some other appropriate measures in place to ensure that that transfer of personal data is lawful. And the most likely measure is going to be the standard contractual clauses that you've already mentioned. But that will, if that's not in place already, that will need the written contractual clauses to be put in place before the end of the year to make sure that that flow of data can continue. And then the lawful transfer to the UK from other countries, David's mentioned a little bit about the position in Switzerland, and I'm not aware of any other countries that have said that there will be any change in their position as a result of Brexit, but I think it will largely depend, as David has said, on what the EU decides to do and whether they are going to give the adequacy decision. So next slide, please. So if any of our listeners are dealing with processing of personal data that comes within the scope of the the UK legislation, then you really need to consider, first of all, what data you are collecting and processing, and your data flows, as I've said, where it's going, where it's collected, where it's going to, and where it's coming from. I think that would be the first step of what you need to do to prepare for Brexit. And if businesses are operating cross-border with the EU, if it's a UK organisation, then they will need to think about supervision within the EU. They may have to appoint an EU representative if they don't have a physical presence within the EU. And also, if they're transferring data, as I've said, the other way from the EU into the UK, you need to ensure you've got the standard contractual clauses in place and checking the requirements in other countries. And then from a very practical point of view, then you will need to consider your the terminology that you're using within your privacy notices and the information that you're giving to data subjects. So if you're referring to your personal data being stored within the EU, but it's actually stored in a data centre within the UK, then you will have to make a change there to make that information accurate. Any transfers of data between the UK and the US, again, it's ensuring that the the privacy shield will apply. It is still going to be recognised by the UK, and it is still going to be in place. But we need to, the organisations will need to ensure that the US company has declared that it is complying with the privacy shield for transfers to and from the UK specifically. Okay.
All right.
Yeah.
I have one question, Karis.
Yes.
Is there any chance that all of you will come to your senses before the end of 2020 and just stay with the group?
I think that chance has passed, Bart.
Yeah, unfortunately for everyone, I think. But anyway, serious question now. How do you figure foreign companies should look at Brexit? If I'm, let's say, an American company with a European head office in London and branches in Germany and in France, and my servers are in I don't know, in the Czech Republic, my data is spread between the UK, the EU, and the US. Should I be worried about Brexit? Should I move everything from London to the mainland, or from the mainland to London? Or
yeah, I don't think it's necessary to move data, but it is going to be necessary for them to consider if again the direction of travel of data and where it's going to and from, because they may need to put some standard contractual clauses or other measures for if that's required by other foreign legislation in place before the end of 2020.
And maybe have two representatives, one in the EU and one in the UK.
Possibly, yeah. Yeah.
All right. For the other European panel members, would you say that your clients are aware of the impact Brexit might have on their data processing activities? Are they worried? Should they be?
Most of my clients were aware of it, but since basically the beginning, where it was, still an option that it could happen. And well, I don't think worry is the right word for that, but just, try to be prepared, basically. Yeah. Just have the necessary contractual language in place to ensure that, you can just continue with your service provision should Brexit happen, which now it's going to.
Yes, absolutely. That's the same for my clients. They really want to anticipate the Brexit. So we are working on it with them and helping them to anticipate any difficulties or worry.
That's mainly for the ones that know and realize that they are exchanging data with the UK. A lot of companies, I believe, are also, I don't know, using some online service without even knowing where the service provider is located. So I fear that the awareness level with a lot of companies is almost below zero if it comes to international data transfers, unfortunately. Maybe we should ask one of the non-EU panel members to give their view as an outsider on the entire Brexit situation. Lucia.
Yeah. Well, I think that from the Chinese point of view, from the Chinese company, from the commercial point of view, Brexit could be an opportunity, because for the Chinese companies, EU is not an entity, it includes a lot of countries, but for the Chinese, one country is a contractual party. Then, considering that now there is Brexit, the UK could be a new contractual party with new rules, etc. So I think that Brexit, in this regard, speaking also with some of my Chinese clients, is not a problem, is not a concern, could be a new opportunity to start new relationship.
Very smart. Never see a problem, always see an opportunity. It's a good way to attack life. All right, I had one question that came in from Steven Segard or Segard, I don't know, on the previous topic. Not really a question, but more a comment. Steven said, as a small service provider, freelancer, the prospect of being audited is quite daunting and potentially expensive. I would need to shield information from other clients in order to allow for an audit by one of my clients. Understandable, I think, but at the same time, GDPR contains a basic right of audit between data controller and data processor. So I think Stephen, unless I'm mistaken, panel members, I think Stephen will have to take into account that if he's a data processor for working for a controller, he always will run the risk of being audited at some time. And then the question is, how do you what can you do to avoid the cost, or how can you divide the cost? Is there any experience between the panel members with auditing costs, auditing rights in data processing agreements?
I'm sorry, Karis.
No, it's okay. In my experience, it really depends on the bargaining position of the parties when they enter the relationship. And it's usually decided at the outset as to which party will bear the costs of any audit or whether they will be shared.
I was just going to add that as a small company, that's actually a good argument for you to ask for, particularly if your counterpart is a much larger company. Freelancer to any other size is pretty relative, but you have a good argument in that situation, regardless of what your leverage position is, to say that you can't bear the cost of the audit. And if they want to do the audit, then for purposes of their compliance determinations, then they should either pay the cost or help you in bearing the cost in some way. Usually it's a 50-50 split if it's going to be split, in my experience. The other comment that might be helpful to some of the small companies that are on the call, from the US perspective, there are distinctions in some of the state laws for compliance for small businesses. For example, the New York Shield Act defines a small business and provides a lower standard of, well, maybe not, it's a less specific standard. It's a reasonableness standard for data security compliance. So there is a recognition, at least in some of the states, that smaller companies need a little bit of flexibility in their compliance efforts.
As far as costs of audit goes, something that we have agreed to in the past is that the controller will bear the cost of the auditing unless the audit shows that the processor is not compliant, in which case the cost will be shifted to the processor. That's something that might help solve Stephen's problem, perhaps.
Yeah, I've used that in the past as well.
All right. We have one topic left, and I propose that we start with that immediately, Catherine, because time is
we are over time.
Relentless. Yeah, we're already over time.
All right. I think we've covered some of this and a few of my interjections here, so we can probably move a little bit faster. But I'm just going to speak with you briefly about the impact of COVID as I've seen it in my practice and within other attorney practices in the U.S. So one thing I think that's worth pointing out are, in some instances, nothing has changed as a result of COVID. The California Consumer Data Act is still moving forward. The Attorney General is still moving forward with enforcement efforts that will begin on July 1, which is right around the corner. There was a large lobbying effort when it became clear that COVID was going to have such a large impact on the country, and with quarantining and layoffs and business closures and lots of other balls in the air to juggle for businesses. There was a concerted effort to try to persuade the California Attorney General to delay enforcement, but they have decided that and announced that no, now is actually the time in which companies should be much more vigilant. And so they have no intention of delaying. The final regulations were just submitted on June 1. And so that there's the law, CCPA, and then the Attorney General was mandated to issue regulations and the enforcement of the law. So that's the impact and import of those regulations. And they went through many iterations before finally, I think this is going to be the final. the final version that's out now. CCPA application to employees was extended to 2021. So initially they had been included. That's not really an impact as a result of COVID, but just something to be aware of. The New York Stop Hacks and Improve Electronic Data Security Act, which I can't help but smile when I read the acronym, because I feel like they came up with the acronym SHIELD Act and then developed the description to fit it. That was also recently signed into law, and I think there was some interest in seeing a delay in its enforcement, but the data security requirements did still go into effect on March 21st as planned. And the New York Attorney General has indicated that an interest basically in this area. And one way in which she's recently expressed that interest is by following the Zoom, the news about Zoom and the security issues that have been related to that. And that she issued a letter essentially inquiring as to Zoom's data security practices and what they were doing to comply with the SHIELD Act. The SHIELD Act, under their data security requirements, does lay out pretty specific physical, administrative, technical requirements. And it also requires, unlike GDPR, you don't have to have a sole per individual dedicated to the task of being the data privacy officer, but it does, it is unique in that it does require someone within the organization to be the designated point of contact, but that it doesn't have to be the person's sole job responsibility. Next slide, please. So that hasn't changed. The other thing that hasn't changed is that the plaintiffs are still active. So some of the states within the US provide a private right of action. Under most of the federal laws, there is no private right of action, but at the state level, at least in California and Illinois, oh my goodness, and Illinois is misspelled, I apologize. In Illinois and California, there is a private right of action. And there have been a couple cases that have come out during COVID. One, Cullen versus Zoom, which I think was alluded to by our audience member earlier today in her reference to the issues with Zoom. And the basis for that suit was that Zoom was sending information to Facebook upon installation and at each open and closing of the Zoom application. Now, Zoom has almost immediately took remediation action to correct that, and it's no longer the case that that's what's happening. But the plaintiff, it's a class action lawsuit, the plaintiffs still claim that the damage was done, essentially. And it'll be for the court to determine whether or not that's the case. Salesforce was also sued, class action lawsuit under CCPA. There are no pending litigations that are specific to COVID and privacy in Illinois. However, the Biometric Information Protection Act, which comes from Illinois, was triggered in a lawsuit filed against Google, which also has causes of action under CCPA. And basically this lawsuit, there's a father who's suing on behalf of his two children who are students, and he alleges that Google violated the Chicago or the Illinois BIPA law, Biometric Information Law, and the Federal Children's Online Privacy Protection Act. I referred to federal laws earlier that are specific to children within the U.S., and that's the one. His allegation is that they violated those laws by collecting, storing, and using personal information, identifying biometric data of millions of school children throughout the country, including thousands in Illinois, without seeking or obtaining the requisite informed consent from any of their parents or their legal guardians. So that lawsuit's being brought in the state of California, but under not only CCPA, but also BIPA. The other thing to note is that these plaintiffs are looking for, when they bring these lawsuits, that obviously CCPA is sort of an untried landscape. It's the sort of Wild West in many ways. So the plaintiffs' counsel are not only filing causes of action under the statute itself, but they're also including causes of action under California's unfair competition law, breach of contract claims, negligence, and other sort of known quantities where there's more of a case law history to rely on. And I think, the thought is essentially to see what sticks and how the judicial fact finder applies CCPA or uses one of these other legislative gap fillers, so to speak. Next slide, please. So things that have changed legislatively, before COVID, there was a movement, pretty strong movement, I would say, in the last year or two, to establish a federal level omnibus legislation. Those efforts have stalled. COVID's really taken the priority, I'm sure, as it is in most cases. And the heightened concern now is that with things like contact tracing and temperature taking and health monitoring within the workplace and things like and outside of the workplace, that there's really a more pressing need to try to get a COVID specific data privacy bill in place at a minimum. So there's been a shift in emphasis there, and there have been 3 privacy bills that have been introduced, 1 by the Republicans, 2 by Democrats. And the 2 primary areas where the bills differ are whether or not the federal preemption would apply, meaning we right now currently have, as I mentioned, sort of a patchwork of laws between federal industry-specific laws and state more generally applicable laws. And California, for example, as everyone knows, is very stringent. So the question is, if there's a development of a federal privacy legislation that is less stringent than CCPA, should the federal law take preemption over the state law? Republicans feel that federal preemption should apply, and Democrats generally feel that no, the federal law should be the bare minimum that all states must meet, and if a state wants to go above that minimum, then that's its prerogative. It'll be interesting to see how that turns out, because it's not quite, with other legislative efforts, that argument makes more sense, because the application of the state law is really specific to the geographic region. But in the case of privacy, as we all know, with online tools, it's very easy to go outside of your geographic scope. The other difference is whether or not there should be a federal private right of action. And as I described, there are the states that have a private right of action are in a minority at this point in the US. So we'll see where that goes. We're unlikely at this point to reach a resolution before Congress recesses in August. And some people are very pessimistic that anything will be put into place before the election in November as well. The other change is that, I mentioned this earlier actually, it's just that in some instances, laws that had been sort of expected to go through and pass, such as the 2 in Texas, have been stalled now with COVID. Next slide, please. So turning from the legislative side to how COVID has been impacting us on the ground level, the businesses, and how it's impacted business continuity, I think in addition to creating a very unstable business climate, business operations climate in general, COVID has also introduced a lot of complications with regard to data privacy and security compliance. Because as businesses try to really struggle to survive now, and I want to remind you that I do work with enterprise level companies, but a lot of my clients are also smaller and mid-sized companies. So I'm seeing a lot of businesses who are really struggling to pivot their business model in order to survive without being able to have foot traffic in their brick and mortar businesses, or where their own clients, for example, are suffering, and so they're trying to offer new or different services that are internet based and reliant on personal information. So these companies are really balancing their need to survive against their compliance and the protection and their obligations to protect their customers, users, and employees' data. And we see this coming up in the telework instance. We see it coming up in the increased reliance on third-party services, on the ability to take advantage of some of the government programs that are being offered for relief, and the enforcement side of things. Next slide, please. I'm offering here just a quick sort of case study, which I'm not going to go through here, at great length, but I'll just highlight. One of the clients that I recently worked with is in the hospitality industry, which has taken a large hit. So they went from being a dine-in service restaurant to, may I take your order for delivery? They're, it's a high quality restaurant with locations in Turkey and in the U.S. And so the question became, okay, well, as a restaurant providing an in-dining experience, we collected certain data. Can we now use that data set to pivot to this new business model where we're going to be doing orders for delivery? And oh, by the way, where we never needed to before, we now have to contract with things like as a DoorDash and Grubhub and Seamless to affect and Uber Eats to affect that transaction. So these are really very pressing, time-sensitive contract negotiations that are going on, where there's really a need to take data privacy into consideration. And I feel fortunate that I'm working with some clients that are actually taking that into consideration, because I'm aware that there are likely many, many more who are just simply throwing that to the wind in an effort to survive. And the question came up in this instance about cross-border transfers, which I thought might be interesting to the constituency on the call today, because there are no restrictions on the transfer of data outside of the U.S. personal data. There are restrictions on technical data transfers. But in this instance, it was a question of, okay, well, we have great services in Turkey, third-party services, and can we transfer data of our customers? We want to, provide this delivery service locally in a few states within the U.S. Can we transfer that data over to Turkey in order to get our vendor over there to do an email blast? Well, I think the answer was, of course, you can transfer it out, but when the Turkish service provider turns around to actually transfer the data back to you, what regulations apply to that? And is that a cross-border transfer of data? So those were sort of some of the issues that came up. I have also seen during COVID, actually apart from the clients who are doing these really quick pivots in their business models, with some of my other technology clients who have not been as impacted by COVID, I've been seeing an increase more attention to internal compliance, data security compliance. It's almost as though they have the time right now, so they're taking an interest. Next slide, please. This is my last slide, and it's just sort of some of the observations that I've noted among my colleagues and my own practice in terms of what novel issues are being presented and coming up in the U.S. Specific to COVID. And those are some of the issues, privacy concerns on contact tracing. Many states, as we've talked about, don't have comprehensive data privacy and security laws. So, but almost all states are looking at contact tracing efforts at this point. So that's another interest at the reason or impetus for the federal interest in passing some sort of legislation on that effort. There's the temperature screening, the testing results and verifications, inferences about one's unhealthy or healthy appearances and whether or not that could be considered personal information. I think under California's CCPA it would be, but maybe perhaps not, under the New York Shield Act. And I had a question recently come up actually just the other day about, okay, so we used to use there's it's the Federal Telecommunications Act that governs sort of the robocalls, what people commonly understand to be robocalls here. And the question is, okay, now that we can no longer provide an in-person experience, what we would usually provide our customers if we're doing the same thing or trying to simulate that experience over Zoom, but we're recording the calls for customer service improvement and, you know, the sort of regular things, nothing nefarious, but, you know, is that biometric information is, you know, yes, it is. But I think that most of my clients aren't really conceiving of that as adding an extra layer of compliance that they now have to take into consideration and cost. So, and taking temperatures as an example, just to show you the different, the variety of different laws that would apply. We've talked about BIPA and CCPA, New York Shield Act, Washington, Texas, and Arkansas also have biometric, also include biometric information in their definition of personal information. The EEOC, which is the federal agency designated over equal employment opportunities, requires temperatures to be treated as confidential, but otherwise there are no specific requirements. And the Americans with Disabilities Act, another federal framework, requires that information be stored separately from personnel records, but that's the only requirement. So, you know, for many of my clients, the question as they get ready to go back to work and bring their employees back in is, you know, should we get consent for this? And I think the answer is, you know, yeah, it's not a big lift to get the consent. Everyone, I think, is expecting some sort of monitoring as they go back to work. And if you can get it from your employees, you can, in many states, it can be a condition of employment to give that consent, similar to how you implement your employee privacy policies. You know, why not do it? Because it may save you definitely some headache on the other side. And with that, I wanted to open it up to the other panelists to see, you know, that's sort of from the US perspective, but if we have time and our audience is still with us, maybe we can hear about how COVID is impacting my colleagues in the other countries.
We have very little time left, so we'll have to limit ourselves to 2 or 3 questions, I think. First reaction, Catherine, from my side. Getting consent for temperature measurement or processing biometric information in the EU under GDPR is very complicated from personnel members, because if you ask for their consent, they have to be free in giving it or refusing it. And generally, we consider that an employee is not in a situation where we can refuse his consent. So the unbalance in relationship between employer and employee makes getting a consent very difficult. So it's interesting to hear that consent in the US for employees seems to be a little bit more obvious than it would be from our point of view.
I think it definitely varies state by state in terms of whether consent would even be required. But I think, you know, best practice is a real thing, and it's something that I often will, you know, counsel to my clients. And you just never know where you're going to end up. And you know, the U.S. I think is known to be a very litigious country. So if you're able to get that consent, and we don't have the same considerations as what you described in terms of the natural sort of imbalance of power between the employer and the employee. So if you can get it, it definitely is an added protection to mitigate your risk.
Lucia, one of the things I was wondering while Catherine was speaking, I read in the newspaper that there was a new little small outbreak of COVID in Beijing. How does the Chinese government look at the tracing app fuzz that we've seen in Europe, because everybody's afraid for their privacy once the government starts tracing people through apps? I have a slight feeling that the Chinese government doesn't look at that the same way as we do over here.
Yes, but for China, it's not so an innovation, because in China, usually there is the facial recognition, there is the collection of the data of the person, but it is not strange for the Chinese, because, for example, you may imagine that with such kind of facial recognition, today in Shanghai, it's possible to find a criminal in around 10 minutes. So it's impressive. And for the population, for the Chinese population, such kind of use of the data for the benefits of the population could be useful. So comparing with Europe, the use of such app is not so strange because it's something that is common in China. It is strange for foreigners, it's strange for foreign invested companies, for example, because recalling what Catherine is saying relating to the COVID-19, for example, all the foreign invested companies should collect the data of the temperature, etc., without consent, because it's necessary to protect the companies and the population. And for example, for the foreign invested company, what we have implemented is to comply with the Chinese law, with the Chinese measures, and also to prepare a policy that could comply with the Chinese rules, but could also provide the information, the notification to the employees, because a lot of foreign invested companies has also the foreign employees, the expatriates.
All right. Do any of the EU panel members have anything to contribute to this discussion? Or any questions for Catherine or Lucia?
Just on the temperature, taking employees' temperatures, the ICO has actually given some guidance in the UK that consent isn't required, and I think the reason for that probably is because of the difficulties in getting the GDPR level of consent, as you mentioned, Bart, and that the legal basis for processing that data would be in the interests of public health. But they are focusing more on data minimization and then what you do with that information once you've collected it. So it's not keeping it. Once you've taken the temperature, you don't have to retain that information. If you do have an employee whose temperature means that they're not allowed to stay at work, that you inform other colleagues and anyone else you might need to inform about that, but you don't disclose the identity of the person. So you don't disclose or share their personal data in that way. So it's more on the what happens afterwards rather than whether you need consent to get it in the first place.
Yeah.
I would say that there's also an awareness of that on our side in the US. It's just like what Karis was saying, the consent to secure in the initial instance is one question, but there's also an enormous amount of sensitivity around what you do with the information and limiting disclosure as much as possible to people who do not need to know.
Yeah. Okay, any last comments? Because we are way over time and I don't want to stand between people and the end of their working day or the beginning of their working day in some parts of the world. Nothing more? Then I want to thank all the panelists. I think we have one last slide giving our contact details. Thank all the participants, those of you who stuck around until the end. Thank you. That's very, very that you merit our respect by sticking around until the end. Listening to lawyers for 90 minutes is not easy. If you have
thank you, Bart, and let me thank you in the name of Consulegis and in the name of thank you for all the speakers and all the participants. I think it has been a very, very interesting session, very practical, many issues, many heartaches to come for many people. Probably, and many questions probably to raise in the future. So thank you again for joining. I know it has been a little bit longer than expected, but I think it was really worthwhile and worth it to stay and to have this global vision from one continent to the other, going from one to the others. And right now there are so many issues on data protection as we have. Zoom was the epicenter and solved it, but we are happy that everything went beautifully. Thank you, and I hope to see you again in one of our next sessions in another topic and probably one related to IT and data protection. Thank you so much, everyone, and see you soon.
Thank you.
Thank you.